Hello friends, welcome. In this video, I will discuss the Nairobi International Convention on Removal of Wreck. This convention was adopted on 18th of May 2007 and came into force on 14th of April 2005. I will try to cover most of the aspects that you need to know with examination point of view. So let's get started. So from the name itself, you can understand that this is something to do with the wreck. So if a ship becomes a wreck, it is sunk. What happens to it? It is estimated that number of abandoned wrecks all over the world are around 1300. Until Nairobi Convention, there was no such rule that decides who is responsible for the removal of wreck. There was no regulation that decides what is the role of the coastal state or the owner of the wreck. A wreck may cause three kinds of problem. It may be a hazard to navigation, potentially endangering other vessels and their crew, and depending on the nature of the cargo, it may cause a potential damage to the marine environment or the coastal environment. And third, the cost of getting a wreck removed or even marked is getting more and more expensive with time. To solve all these issues, the convention provided a sound legal basis for the coastal states to remove or have removed from their coastline wreck which poses a hazard to the safety of navigation or to the marine or coastal environment or both. The treaty also covers any prevention, mitigation, or elimination of hazard created by any object lost at sea from a ship, example, a lost container. Now, let us discuss the key points from the convention. This convention applies to any wreck which is in the exclusive economic zone, or in case there is no exclusive economic zone, then up to a distance of 200 nautical miles from the baseline of any state. As per the convention, ships of 300 gross tonnage and above and offshore installations must maintain a cover as per the Limit of Liability Convention 1976. This convention does not apply to the warships, government ships used for non-profitable operations. It applies to any sunken ship or a ship about to sink or any object from a ship which has sunk, stranded, or adrift. Basically, anything which poses a danger to navigation. All the parties and the state to take responsible measures for the removal of wreck. Master and the operator, if obliged to report any casualty resulting in a wreck, such report must have name and principal place of business of the registered owner, and all other necessary information like location, type, size, and construction of the wreck, nature of damage and condition of wreck, nature and quantity of cargo. The affected state shall inform all concerned and mark the wreck. The ship owner is liable for the cost of locating, marking, and removing the wreck, unless the ship owner can prove that it is caused by the mistake of the government for not maintaining a navigational mark, or it was an act of war, hostility, civil war, or a natural phenomena of exceptional or inevitable character, or if the damage was caused by a third party with the intention of causing damage. So let us understand what is the sequence in which the things will work if there is a marine casualty which is leading to a wreck. The particular affected state marks the location of the wreck. It informs the state of the ship's registry and owner of the wreck. The affected state then requires the owner to remove the wreck within a reasonable deadline, failing which the affected state may remove it at the owner's expenses. These expenses, including the cost of locating and marking the wreck, is recovered from the owner. Thus, there is an insurance requirement on the owner's side. Every ship of a state party, 300 gross tonnage and above, must have an insurance to the limit of liability for wreck removal as set out in the national law, but not exceeding the upper limit in the Convention on Limit of Liability for Maritime Claim 1976 as amended. Further, there is a time limit for the owner to take action. Right to recover are extinguished if the action is not taken within 3 years after the hazard is determined by the coastal state. But in any case, it cannot be extended more than 6 years after the marine casualty that had caused the wreck. The Nairobi Convention defines wreck following upon a maritime casualty as A sunken or a stranded ship. Any part of a sunken or stranded ship, including any object that is or has been on board such a ship. Any object that is lost at sea, from a ship that is stranded, sunken, or adrift at sea. A ship that is about to or may reasonably be expected to sink or to strand, where effective measures to assist the ship or any property in danger are not already being taken. India ratified the Nairobi REC Convention in 2015, and as per MS Act 1958 as amended, REC is defined as follows. Wreck includes the following when found in the sea or in tidal waters or on the shores thereof. Goods which have been cast into the sea and then sunk and remained underwater. Goods which have been cast or fell into sea and remained floating on surface. Goods which are sunk in the sea but are attached to a floating object in order that they may be found again. Goods which are thrown away or abandoned, or a vessel abandoned without the hope or intention to recover. So, if you carefully read both these definitions, it's clear anything which is sunk, may sink, or floating, either a ship or something that has fallen from a ship, includes a wreck. Whether the owner has intention to recover it or not recover it, it will be considered a wreck. The articles in the convention also cover the criteria for determining the hazard posed by the wrecks, including depth of water above the wreck, proximity of shipping routes, traffic density and frequency, type of traffic, and vulnerability of port facilities. Environmental criteria, such as damage likely to result from the release into the marine environment of cargo or oil, are also included in the criteria. So, finally, I summarize, Nairobi Convention on the Removal of Wreck is about dealing with the wrecks. It sets out guidelines for the ship owners and the coastal states on how they are supposed to go about it. The convention clearly identifies the right of the coastal state to remove a wreck from the exclusive economic zone. The convention covers the definition of wreck hazard. It also talks about the financial liability and maintenance of compulsory insurance by the ship owner. And the convention gives a strong reference to safety and protection of environment. I hope this was a useful video for you. If you have any feedback, suggestion, or comment, then please do write down below. All the best for your exams, and as always, thank you for watching.